What are little girls made of? Well, the nursery rhyme says sugar and spice and everything nice. The truth really comes down to biology. The question before the court in these cases is whether, under Title IX and the Equal Protection Clause of the 14th Amendment, schools may maintain women's and girls' sports teams for biological females, i.e., may schools determine eligibility for female sports based on biological sex. In the past 6 years, 27 states have enacted laws that maintain female sports for biological females. Are girls and women's teams only for the female of the species? At least 27 states have enacted laws saying so. West Virginia's law has been challenged. In 2021, West Virginia enacted the Save Women's Sports Act, which prohibits male students from playing on female teams. The law specifies that sex is determined by biology. The legislature expressly found that prohibiting biological male participation in female sports is necessary to promote equal athletic opportunities for women and girls. Seems pretty straightforward to me. Male students are prohibited from playing on female teams, and that distinction is made by biology. Respondent, BPJ, who identifies as female, is a biological male. I can claim an identity as a tuna fish sandwich, but that does not make it so. Neither is what a person thinks about themselves a scientifically or legally established fact. BPJ has sought to participate in girls' cross-country and track and field teams at school. BPJ sued West Virginia and relevant officials for alleged violations of Title IX and the Equal Protection Clause of the 14th Amendment. BPJ is a boy who wants to play on girls' athletic teams. He claims that West Virginia's laws prohibiting this violates both federal law and the 14th Amendment. What do the courts think about this claim? The U.S. District Court for the Southern District of West Virginia granted summary judgment for the state on both claims. On appeal, the Fourth Circuit reversed on a Title IX issue and remanded for further fact-finding on the Equal Protection Clause claim. So the district court said the state was correct on both claims, but the Fourth Circuit disagreed, at least on the federal law question. West Virginia wasn't the only state sued. The facts in both of these cases are very similar. In 2020, Idaho enacted the Fairness of Women's Sports Act, which prohibits male students from participating on female teams. The Idaho law states that sex is determined by biology, and the law declares that separate sex-specific teams furthers efforts to provide sex equality by providing opportunities for female athletes. It also recognizes the physical difference between biological males and biological females. The law further found that the benefit that natural testosterone provides to male athletes is not diminished through the use of puberty blockers and cross-sex hormones. Sounds almost identical to the West Virginia law. I think you'll find the complaint similar, but not identical. Respondent Hecox, who identifies as female, is a biological male as defined by the Idaho law. Hecox competed for the women's club soccer team and tried out for the women's Division I track and cross-country teams. Shortly after Idaho enacted the Fairness in Women's Sports Act, Hecox sued Idaho and relevant officials, alleging a violation of the Equal Protection Clause. The U.S. District Court for the District of Idaho granted a preliminary injunction barring enforcement of the Fairness in Women's Sports Act, and the Ninth Circuit affirmed. Mr. Hecox doesn't argue a Title IX violation, only an Equal Protection Clause violation.